heard, my name is Joy. My name is Joy Katunge Matheka, Council Member-elect, and I welcome you all to today's webinar. So on behalf of our chairperson, Madam Helen Namisi, again, I'd like to welcome you. She's engaged in prior arranged, she had prior arranged engagements, but she would have wished to be with us today. So kindly accept her apology. And taking us down will be an introduction of what the branch is in a nutshell. The branch is a devolved unit of the LSK, that's the Law Society of Kenya, that looks into practice matters of lawyers in Nairobi and Kiambu County, not only practice matters, but also welfare issues and even member participation. And today we're going to be joined by 4 wonderful souls, being Dr. Anne Nyatiti Omambia, I hope I got that correct, Lydia Omuko, Ms. Bianca Gishangi, and our moderator, Immaculate Kemunto. So today we're going to look at a very interesting topic, which is the climate, which is in collaboration, with Climate Change Lawyers Cafe. And the topic of discussion today will be carbon markets and the opportunities that are there for lawyers. So among the things that we look forward to discuss are such as understanding what exactly carbon markets are. This is not the language that you'll hear in corridors of justice. Then there's also an aspect of what are the governing legal frameworks around carbon markets. We look at the best practices, the challenges, and most importantly, what opportunities are there for us legal practitioners. So Dr. Anne Nyatiti, Ms. Lydia Omuko, and Bianca Gishangi will be taking us through this very interesting topic. And again, on behalf of Ms. Helen Namisi, who is our chairperson and the whole branch, we wish you a very engaging session. We're encouraged to ask questions, make use of the dialogue box, the chat box, ask questions, engage us. We're here to learn. So thank you and karibuni sana. Over to you, Immaculate.
Thank you. Thank you so much, Joy, for that. So in the interest of time, I realized I didn't introduce myself. My name is Immaculate Kemunto. I'm the founder of the Climate Change Lawyers Cafe, which is a platform aimed at enhancing a lawyer's role in just climate action. So we'll proceed to our speakers for the day, and then we'll hold a plenary at the end. Please keep your questions coming, and for any questions we may not be able to answer today, we'll be sure to send detailed answers through email. So our first speaker is Ms. Lydia Omuko. Lydia is a climate change lawyer and consultant, and she currently works at Climate Focus. Lydia, are you ready to proceed?
Yes, I am. I will just have to share my screen.
Okay, welcome.
This will take a few minutes. Are you able to see my screen? Okay.
Yes,
yes. Okay, yes. Thanks a lot. Thanks so much, Immaculate, for having me and the LSK Nairobi branch. As Immaculate introduced me, I'm a legal consultant at Climate Focus. Climate Focus is an advisory firm, a climate advisory firm that provides a range of climate-related services to governments, to private entities, to NGOs. And one of the things that we do is on carbon transactions, which is just advising entities that would want to sell and purchase carbon credits on the agreements, on due diligence, and a lot of other things. And we also do climate change policies. And one of the things we do is advising governments on carbon market strategies. Other than that, we do a range of other things that I will not mention, but we also provide training to government entities, to private entities, as well as to law firms on emission reduction purchase agreements, what we call APAs. And this is a service that we've been providing quite a lot if just companies or law firms want to understand how to draft an emission reduction purchase agreement. So I will just get into it and speak about carbon markets, just give a brief introduction of what carbon markets are and what the opportunity for lawyers. Oh, perfect. Perfect. So just to set the scene a bit. So the ultimate objective of the International Climate Regime, that is the United Nations Framework Convention on Climate Change, is to stabilize the concentration of greenhouse gases in the atmosphere to prevent what we call irreversible or dangerous interference with the climate system. And what science tells us is a warming of about more than 1.5 degrees above pre-industrial level. A warming of about 1.5 degrees would be safe. Anything above 1.5 degrees would have irreversible consequences. And this is why under the Paris Agreement that was agreed on in 2015, countries agreed to the goal of limiting global warming to well below 2 degrees, or preferably to 1.5 degrees, because if we go above this, then this is going to be, there are going to be irreversible consequences. And what has been happening is that countries are submitting what we call nationally determined contributions on how they intend to mitigate or how they intend to address the climate change based on their national circumstances. And when we look at where we are right now, we are currently at a warming of about 1.2 degrees Celsius. And looking at the existing climate policies around the world, looking at what countries have pledged, if all this is implemented, this would put us at a warming of about 2.5 degrees. And remember, I mentioned anything above 1.5 would be dangerous. So what we are having here is what we call an ambition gap. We are currently at a route of taking us at about 2.4 or 2.5, and we need to stay at 1.5 degrees. So we have this emission, we have this ambition gap. And what we see is that carbon markets can be one of the mechanisms to accelerate climate action and provide financing that could close this mitigation gap that we currently have. So we see carbon markets is likely to play quite a huge role, or can play a huge role to make sure that we reach our mitigation goals. And what exactly is carbon market? So when we're talking about carbon markets, it basically means putting a price on greenhouse gas emissions so that either one trades the permission to emit, or you trade an emission reduction that has happened somewhere else. So it's basically about putting a price on carbon. And at the moment, there are currently two types or two forms of carbon markets. One of them is the emission trading scheme, or cap and trade. And the cap and trade basically means that the government, that every entity or the government puts a cap or a limit on how much each entity can emit. And if an entity emits less than what they have been allowed or permitted to emit, then they have an extra emission allowance, and this they can sell it to other companies. And the most common one is the emission trading, the EU emission trading scheme, the EU ETS. That is the well-known cap and trade scheme that is currently existing, but there are also others that are at regional level or at subnational levels in different countries. And then the second type of carbon markets is the carbon offset market. And this is where, for instance, a company or an entity or a government buys some emission reduction somewhere so that they counteract or they can replace what they have already emitted through their own activity. So this is the second type of carbon markets. And this is the most common type at the moment. The global carbon markets up to date have nearly exclusively been offsite mechanisms rather than emission trading scheme. And I understand this is the one that is more interesting for the audience here and for us. So I will be speaking, when I speak about carbon markets from now on, I'll be speaking about the carbon offset mechanism. So What would happen in a carbon offset mechanism or a carbon market is that you have a supplier, which could be a project that reduces emissions. This could be, for instance, a project in Kenya that reduces emissions. And what happens is that the emission reductions from this project then generate what we call carbon credits. And these carbon credits then are now sold in the carbon market. And on the demand side, you have a company, it could be, you have a company or you have a government entity that would like to reduce its own emissions, but they're looking for cost-effective ways of reducing emissions. So what happens is that they go into the carbon markets and look at carbon credits that have been generated from projects, in different parts of the world, and then they purchase this, and they purchase this for their own use, either for compliance reasons or because they would like to do it voluntarily. And we see that the most supply of carbon credits, or most projects that generate emission reductions that are being sold in the market, are from Asia, Africa. Kenya has quite a number of them. Congo, Ghana, there are quite a lot of them in Africa, and then also in South America. And where are they being bought, or where is the demand coming from? The demand at the moment currently is mostly in Europe and North America. This is where you find companies or governments that are buying carbon credits. So the next thing to talk about is who are the participants in a carbon offset market. The first one is usually the project developer, and that is the main person in the carbon market, in a carbon market or a carbon project. So you have the project developer, who is just the team that designs and implements the whole carbon offset project. And then the government could come in to either approve projects, could be providing licenses. For instance, if you need an EIA for a certain type of project, then the government will come in. But also under the clean development mechanism, which we'll be talking about in a few, the government used to issue what we call letters of approval. And now they are likely to issue what we call letters of authorization under the Paris Agreement. And I think Bianca will be talking more about that. And then other than the project developers and government, you have what we call the carbon standards, or the standards bodies. And these are the organizations that certify and set the criteria for carbon offsets. And I'll give you an example of a few of them. And then once you generate these carbon credits as a project developer, they are sold to buyers, and buyers could be investors, could be corporates, could be individuals. And sometimes you find that there are brokers in between. It's not a must, but they're usually sometimes brokers who put together buyers and projects. So how are carbon credits generated? Usually carbon projects fall into two main categories. The first one is what we call emission reductions or avoidance. And these are projects that prevent or they reduce the release of emissions into the atmosphere. And examples could include large-scale renewable energy projects like wind projects. You have geothermal, hydro, so quite a number of large-scale renewable energy projects. Then you also have community projects like energy efficiency projects. These are quite common. The cook stoves, the improved cook stoves. I think most of us have seen it back home. At the moment, they're becoming quite many that instead of families using 3 stones, then they replace this with efficient cook stoves, and this means they use less fuel wood. And if they use less fuel wood, then they're avoiding a certain amount of emissions being released into the atmosphere. And then another type is what we call avoided deforestation, which because of this project, then deforestation has reduced. And one example of this project is what we call the Chulu Red Plus project that is currently being implemented around Chulu Hills. Then on the other hand, we have the second type of projects, which are removal or sequestration projects. And these are projects that remove carbon from the atmosphere. The most common types of these projects are usually forestry, because we know forests usually absorb carbon from the atmosphere. And examples of these projects that are currently existing in Kenya, you find there are a number of agroforestry projects where project developers will collaborate with farmers, and then farmers will plant trees and will plant trees in addition to their normal crops. So these are one of the kind of projects that are happening in Kenya. Then you have the mangroves projects where mangroves are being planted around the coast, and there's the Mikoko project there. And finally, another type of a removal project is the soil carbon capture project, where there could be some sort of rangeland management, where there's rotational grazing or some form of sustainable land management practices that do not lead to degradation and allows the soil to capture carbon. So these are the main two types of projects. And then once the reductions or the avoidance happens through projects that could be, for instance, in Kenya, there are certain bodies or standard bodies that actually certify and verify that these emissions are real, that these emissions actually happened. And then now they convert these emission reductions or removals into a tradable unit that we now call carbon credits. And at the moment, there are quite a number of standards that are existing, that are currently existing. But the 5 main ones that take about 90% of the market transactions at the moment, you have the Clean Development Mechanism that was under the Kyoto Protocol, but now we're expecting a new market mechanism under the Paris Agreement. And then for voluntary carbon markets, we have the VCS, the Verified Carbon Standard by Verra. Then we have the Gold Standard, we have the Climate Action Reserve, and the American Carbon Registry. So these are the main carbon standards that actually convert or provide guidelines on how you can convert the emission reductions or removals into a tradable unit that could be carbon credits. So how are carbon credits being used once they have been generated, and how are they being used? In the past, when I talk about in the past, that was under the Kyoto Protocol, and now we have the Paris Agreement, which Bianca will be speaking about. But in the past, it was quite clear on what we call the compliance market and the voluntary market. So the compliance market was under the Kyoto Protocol, where developed countries had a binding mitigation obligation compared to developing countries. And what they could do is that they could buy carbon credits from projects in developing countries to comply with their emission reduction obligations. And then on the second side, you had the voluntary one, which was just corporates who are buying carbon credits to compensate for their own greenhouse gas emissions. But now what we see is this is kind of now mixed up together. So as much as the market right now is mainly voluntary carbon markets, where carbon credits are being generated by the voluntary standard bodies that are there. What we are seeing is that these carbon credits that are being released through voluntary carbon projects are sometimes being used as part of regulated system. For instance, South Africa has a carbon tax, or even Colombia also has a carbon tax. And what happens is that the South African system allows entities to buy carbon credits from voluntary projects so that they can comply with their carbon tax obligations. So this is how we see carbon credits being used for compliance reasons. But then other than that, we're also seeing a huge demand by corporates to actually who are voluntarily buying carbon credits for various reasons. They do not have any compliance. They're not required to comply by any standards or by any emission reduction obligations, but they're buying these carbon credits for their own voluntary reasons. And this is becoming quite a huge market at the moment. And so the question would be, why are companies buying this voluntarily anyhow? And we see from 2015, after the signing of the Paris Agreement, a lot of companies pledged that they are planning to be net zero by 2050, 2030, or that is one of the pledges that companies have made. Also in their own internal strategies, companies are planning to be carbon neutral, to clean up their supply chains and production systems. And a lot of consumers, especially in developed countries, are holding companies to account for the promises that they're making in terms of climate goals. So because of this, companies are buying carbon credits from projects so that they can fulfill these pledges, or so that they can offset their own emissions and they can claim that their products are carbon neutral. So these are some of the reasons why companies are buying. And as I mentioned, we are seeing an explosion of carbon credits, especially since 2015, since the signing of the Paris Agreement. And just on the left side, you can see how from 2016, carbon credits have really shot up. And this is also being reflected in Kenya. If you see the amount of projects that are now being developed, if you see the carbon credits that are being issued in Kenya, we see there's a trend, an increasing trend that reflects what is happening globally, especially from 2015, there's quite a steep increase. And one would ask, who is buying the carbon credits from projects in Kenya? There are quite a range of buyers who are buying carbon credits in Kenya. We have Shell buying the largest percentage of it. You have companies like Gucci, you have Netflix, you have Kering. These are all companies that are buying carbon credits from projects in Kenya, just to give an overview. And as much as carbon credits are becoming such a huge thing, there are a lot of issues that usually they are tagged to. First of all, carbon credits as a whole concept is quite controversial. I have to say that, because it's like, why would one company then just be allowed to emit just so that they can buy somewhere else? But so this also makes it, this also means that anytime you're transacting or you're working on a carbon credit project, then you have to make sure that it is as verifiable and it is as clean, as good, as much as you can, because its carbon credits are quite controversial. And some of the issues that are usually raised in carbon markets, for instance, I'll just go through them quite fast because we don't have much time. One of the issues is whether actually the offset that is being sold, or the carbon credit that is being sold, is it real compared to emissions reduction that were actually generated in another country, or have they been inflated? And these are usually issues of determining the baseline, because you have to determine, for instance, in a deforestation project, you have to determine what would have been the deforestation that was avoided. So you have to determine a baseline. And then also other issues that usually have to be considered is, for instance, if it's a forestry project and you're getting carbon credits from it, but then the forest burns out, then what carbon credits are you getting? What is being removed from the atmosphere, yet you're getting something for this? So these are issues that usually have to be considered, and the certification and auditing system usually takes care of this. But actually, from a legal perspective, the biggest issues are usually things like carbon rights. Who owns? You know, now you're having something that has been reduced, you're having emissions that have been reduced or removed from the atmosphere, but who has the ownership of these emission reductions? So these are issues that usually have to be determined. Is it, for instance, if it's a cook stove, is it the women who are using the cook stove? Are they the ones who have the carbon rights, and how do they transfer it to the project developer so that the project developer could be able to transfer it to a buyer? So these are the issues that arise. And then you have issues of safeguards. How do you make sure that these projects are actually not causing social and environmental harm? And then in terms of benefit sharing, what are communities benefiting from this, from carbon markets? These things are being implemented in areas where communities have been living. How are they benefiting from it? And also, some of these projects are done where communities are actually on land owned by communities. So how do you ensure that communities are actually getting what they deserve? And then you have issues of double counting, just to make sure that emission reductions that have happened are not being counted twice and are not being sold twice. So these are issues that usually have to be considered. And finally, there's something we call additionality, where we have to say that, for instance, if there's a law that says that deforestation should not happen, it's illegal for deforestation to happen, then if you develop a deforestation project, you're just complying with the law. There's nothing additional you're doing. And additionality is something that must be considered for you to be able to generate carbon credits. So in my last slide, what would be the role of, and I'm happy to take up questions after this, I'll just rush through this. So what are the role of lawyers in carbon transactions or in the carbon market? The first thing that lawyers usually are asked to do all the time is, for instance, drafting and providing advice on carbon contracts, what we call the Emission Reduction Purchase Agreement, the APAs. It's lawyers who advise entities on drafting term sheets, on drafting letters of interest, on drafting the contracts. And also just if you have contracts that involve pre-financing of projects, all these things, it's lawyers who are required to, who actually advise and who draft these contracts. And then you have, for instance, due diligence for buyers. As I said, carbon projects usually are tagged with, they already come with a bad name. So for buyers are usually very careful to make sure that there are no legal risks, there are no environmental risks, there are no reputational risks. And this is all the work that is being done by lawyers. And in terms of also due diligence for project developers, when a project developer comes to Kenya, they'd like to understand what is the law on carbon rights, how do I get this, how do I get the carbon rights? How do I get the title to the emission reductions to be able to sell it to somebody else? And then in terms, the second kind of way lawyers could be involved is in terms of policy and regulatory. As we know right now, last year in Glasgow, there was parties or countries agreed on the rules on carbon markets. So carbon markets under the Paris Agreement are now being implemented by countries, and countries will need to come up with laws, will need to come up with regulations and strategies on carbon markets and how they engage in this. And this is an area lawyers could get into. And then also just looking at national frameworks to ensure that when projects are being developed, there are safeguards for communities, there's benefit sharing, and how carbon rights are determined. And finally, in terms of community engagement, there's a lot of capacity building that needs to be done on the rights of communities when projects are being developed. And this is a need we realize in a lot of countries where communities are not being engaged, and they also do not understand what their rights are in terms of carbon markets. So that is one area that lawyers could get into. And finally, just to ensure that project developers are complying with the social and environmental safeguards, such as human rights, environmental requirements. Yeah, so I think I will leave it at that, and I'm happy to take any questions. And if you want any further resources on voluntary carbon markets, there's this voluntary PCM primer that was developed by Climate Focus, and provides really short, brief, and up to the point information on voluntary carbon markets. Yeah, thank you, Emma.
Thank you so much, Lydia. This is definitely a very, very interesting and important conversation. It's a bit sad that our time is limited, and it's a conversation we are happy to, push forward. Please keep your questions coming. Our next speaker is Dr. Anne Mambia. Dr. Anne is the Chief Compliance Officer and Climate Change Coordinator at Kenya's National Environmental Management Authority. Dr. Are you ready to proceed? Dr. we can't hear you. I don't know whether you can hear me. I see you speaking, you're unmuted, but we can't hear you.
Can you hear me now?
Yes, please proceed.
Can you hear me?
Yes, we can hear you.
Okay, apologies for that. I think I hadn't fixed my earphone well. Thank you very much for giving me this opportunity to make a presentation. I am not a lawyer, and therefore I would apologize if I say something which is not legal. I'm not learned, but I am educated, and I hope that you can see my slide. Are you able to see my screen share?
Yes.
Okay. Thank you for the introduction. My name is Nyatichu Mambia, serving the National Environment Management Authority. I am an environmental scientist with a PhD in environmental engineering, specializing in climate change mitigation. Basically, one of the things that we just learned about from the previous speaker, and I will try as much as possible to just carry on from where she left by making a very brief presentation. I realized she's covered some of the elements, and I'll therefore just proceed. I will talk about the policy, legislative, and institutional framework of climate change in Kenya. by stating that Kenya is a member state of the United Nations Roma Convention on Climate Change. This was entered into in an international treaty that was concluded way back. I think we are all aware of the Rio Conference of 1992, those in the environment and legal space. And this particular summit, which was known as the Earth Summit, came to a very important conference where 4 conventions were backed, being the formation of the United Nations Environment Program. So that is Rio plus 50. The Rio 1992 was the first one. Then in 1992, another conference was held. And then now the most significant one again was held last month, not in February, at the United Nations Environment Assembly's 5th session in UNEP. And another one to celebrate 50 years of establishment of the environmental movement will be held in Stockholm in June. That is about 2 weeks to go. That is called Stockholm Plus 50. And again, significant decisions were made in the Stockholm Conference 50 years ago. So in this particular Earth Summit, 4 conventions were established to manage the environment because the world realized, 1, our biodiversity was being lost. 2, the chemicals in the environment were persisting for too long. 3, the desert margins were expanding and causing dangerous interference with human ecosystems. That is, and 4, the climate system was also changing. So 4 conventions were established: the United Nations Framework Convention on Climate Change, the United Nations Convention on Combating Desertification, the United Nations Convention on Biodiversity, UNCBD, and then the one on UPOPs, United Nations Convention on Control of Persistent Organic Pollutants. The UN POPs has given birth to other conventions, including the Stockholm Convention, which relates to chemicals management. So under the chemicals management, we have conventions that manage mercury, which is the Minamata Convention, that which manages persistent organic pollutants, that which manages transboundary movement of hazardous wastes, the Basel Convention. We call them BRS, Basel, Rotterdam, and Stockholm Conventions. And you can realize all these are named after cities. And that's why the decisions were made. I think lawyers will explain why we must name them under the cities. But it's about 30 pages. The Kyoto Protocol is also about 30 pages. So the Paris Convention even shorter. And so you are able to see what this is all about. The main objective, the convention and its the protocol and the Paris Agreement, they are all aimed at stabilizing greenhouse gases. We are not removing them completely. We need them to have the normal right environment to live in, but they have become too much. They're bringing discomfort. So we just want to stabilize them to live comfortably. And decisions are made through a conference of parties annually. Due to COVID, we were not able to hold a meeting in 2020, but last year we met at Glasgow, and this has been referred to. The decisions are guided through both science, technology, and also tracking progress. Those are done by 2 subsidiary bodies referred to as the Subsidiary Body for Scientific and Technological Advice, SABSTA, and the one which tracks implementation, what we're all doing, is called the Subsidiary Body on Implementation. Kenya has ratified both the convention, the Kyoto Protocol, and the Paris Agreement. The protocol specifically is therefore a compliance regime, which has been referred to by lawyers, and it sets obligations, which were previously referred to developed countries who have been identified. Developed countries, this protocol is based on the polluter pays principle, an environmental principle, which I think those of you serving in the environment and land court are aware that is often referred to. And it is based that the developed countries, which developed in the industrial and agrarian revolution, used a brown path of development, the opposite of green, in the sense that it was heavy fossil fuel based, heavy in chemical use, heavy in land destruction, hence the three referred to. Specific to climate change, they bear the brunt of polluting the atmosphere by increasing greenhouse gas emissions to the industrial path. They were therefore given obligations and they were set targets which they are graduated to countries' contribution, which was determined then and when the Kyoto Protocol was being done. And they were given flexibility mechanisms to implement those targets. The emission trading scheme, which has been the development mechanism, and the joint implementation. What are these gases, these greenhouse gases? I know lawyers, some of them don't like chemistry. At least I know one in NEMA who doesn't. And it is the greenhouse gases. And while we're all talking about carbon, and yet there are 7+ more, there are even others we call short-lived climate pollutants. It's because if you recall your chemistry, for those who did a bit of it, it's possible to calculate any of these gases and others as an equivalent of another gas. So all these gases have been calculated as an equivalent of carbon dioxide. So that's why we call them emission reductions as a carbon, using carbon as the unit. The way we use the dollar as the global unit of trade. I know that Putin is pushing we use the ruble, but or the way we use the Kenya shillings when we could have your own local village currency. So therefore, we use carbon as the currency. So it's carbon equivalent. So methane oxide, all this are calculated as an equivalent of carbon, and we are able to report them as tons CO2 equivalent. The Paris Agreement is first ever historic global agreement reached where there was not much convention, similar to what we experienced the Kyoto Protocol. Probably asking what happened to the KP. The KP set obligations, or the Kyoto Protocol set obligations to certain countries. They're but there are 194 member states, and I know that there are countries which have not joined as the countries emerge. So this particular one is referred to as the first ever global. All countries agreed to it. It was not perfect, but it got lots of global support. It has 29 main articles that relate to mitigation, which is basically solving the problem. You have mitigation and adaptation. In simple terms, mitigation, you're trying to solve the problem, which is absorb the carbon. It relates all those other gases I've mentioned. Then we have the section on greenhouse gas levels, which is basically forest. Red plus there is not the red in the blood, but reduction of emissions from deforestation and forest degradation and other conservation efforts. Then we have one which is called the carbon markets, create a platform for carbon markets through cooperation. So it's known as cooperative approaches, Article 6. Bianca will mention, and then we do have adaptation, which is coping with the problem. We cope and we also solve it. So mitigation is solving it, adaptation is coping because it's still changing. Then there are those people who have experienced loss and damage due to climate change, an article on it. Finance issues, of course, all these things require money, they require technology, capacity building, what we're doing right now, and awareness and education. And of course, we have Sustainable Development Goals, previously known as Millennium Development Goals, and Goal 13 relates to climate action. So what is Kenya doing? Of course, the Constitution is the guide. We also have the Kenya Climate Change Act, but one of the most important documents that Kenya did to recognize climate change in Kenya is the National Climate Change Response Strategy, way back in 2010. And that set into motion all the other policy and legislative frameworks are now seen from national to county level, and the climate movement, the non-state actors. We have a national policy that was made together with the Climate Change Act 2016. Then to implement all those obligations, we have action. This is for 2017, 2013, 2017. We have one which is winding up, which is 2018, 2020, which is what we are implementing now. And because Kenya is a vulnerable country, we do have a specific Kenya adaptation plan, Kenya National Adaptation Plan. Why adaptation? Africa says adaptation is a priority. Why? We face the vagaries of climate change. We are the least contributors. We are land resource based, and our vulnerabilities are multifaceted, and therefore we must adopt even as we try to solve the problem, which we never largely caused, but can cause as we develop. I will mention the clean development mechanism because that's the role I've been performing for the last few years in NEMA, being the desk officer, or a title referred to as a designated national authority for the clean development mechanism. It has been referred to, and I just want to say success quotes. It had challenges, and they were referred to by the previous speaker, but there were also successes. And these three quotes come from one, the CDM executive chair, board chair then, who said that the CDM has a harnessed entrepreneurial power of markets. The other one is another quote which says that work under the CDM shows action to mitigate climate change and bring core benefits, job creation, poverty reduction, and it has also incentivized very many countries to get into climate action. So the global picture, a lot has been done. Over 8,000 projects now. This is a year-old statistic, so I know there are others, and quite a number of program of activities. Climate change, we have lots of acronyms. And then we also have a component project of activity, which is under POA. Basically, it is a component of a program. For example, you can do a global program to distribute energy efficient cook stoves, Jikokoa. I know you know Will Broder. She promotes one of them called Jikokoa. We have burn technologies. We have quite a number. We have others use firewood, others use cook stove, others use gas, cocoa stoves. Those who have seen Cocoa Networks, it's a CDM project. We have solar lanterns, which many of you have, and probably save you when the power is out. Those have, some of them are CDM projects. In Kenya, we have 20 registered individual projects. By project, we mean it has a boundary, like for example, Olkaria 4 project, or let me say the closest for those in Nairobi, Ngong 5.1 megawatts wind power project. Those who go hiking or live in that neighborhood, you see those turbines standing there, they're CDM projects. 5.1 megawatts and 13.6, they are by KenGen. We also have voluntary carbon projects. By voluntary means between buyer and seller, not going through the regulated market of the UNFCCC. And then we also, all these projects have reduced in Kenya over 1.5 certified emission reduction, 1.5 tons. I never put the unit there, but it's tons of by sectors in energy efficiency services, geothermal, hydro, methane avoidance, that is through biogas and others. Why did Kenya participate? It's because CDM promotes sustainable development. Actually, that is one of the main goals of CDM, reduction of emissions and promoting sustainable development. And therefore, it's consistent within our laws. I think as lawyers, you know that Article 6, not Article 6, but the Bill of Rights gives us a right to a clean and healthy environment. Then we have Article 42, 69, 70, and onwards, which talk about sustainable development and how what we do should not jeopardize the future for them to live comfortably. Then we have the carbon markets. I've also been included in our nationally determined contribution to the Paris Agreement. That is, Kenya sovereignly determined that it will reduce 32% of its emissions by 2030 by the year, based on a baseline which was set in 2010. And I think the previous speaker spoke about what a baseline means. Basically saying that I'm starting from a mud hut, I'm now migrating to my mansion, my baseline is a mud hut. And therefore I'm able to map my progress. Kenya started off in 2010, we set our baseline for 2010 with a target to reduce our trajectory to go green. Some of those projects, like Turkana Wind Power Project is a CDM project, the largest wind power project in Sub-Saharan Africa. I've mentioned about KenGen. They are the largest CDM project, individual CDM project developers, over 500,000. Then
And we've lost you. Still can't hear you.
Can you hear me?
Yes, now we're good.
My apologies. I don't know where you lost me at.
At Lake Turkana Wind Power.
Okay, I just
the
mentioned that
previous slide, yes.
we have projects. These are some of the projects. They are quite a number, as you saw the statistics. I just want to flag them out. Some of them are familiar to us. Wind power projects, the sum of projects by KenGen, afforestation project by Greenbelt Movement, and other players which were mentioned by the previous speaker. Why did we bother to participate? It's because CDM is important to us, and it is important in terms of job creation and others. There are other initiatives which came up over time under the CDM, which include offsetting the aviation sector. It is known as Carbon Offset and Reduction Scheme for international aviation, where Kenya Airways is participating in, and the KCAA, Kenya Civil Aviation Authority, is our focal point. There are also reserve-based climate finance mechanisms, where the World Bank and other initiatives have been set in place, and voluntary carbon markets. What have we learned? That CDM has learning by doing, because it was a fast market created. We had to learn as technical officers, we had to learn as project developers, and otherwise this was mentioned, the people involved. And also that be able to gain the early bird catches worm of carbon market. And therefore, as Bianca starts on the Article 6, the rating process, the contracts that need to be signed, the terms of engagement, ensuring that communities benefit and all that was mentioned, we need to be ready for concerns right now. As we transition, a lot takes place in transitioning, and therefore revenue streams in terms of pricing come into place. The risk to dilute our NDC, I think she mentioned about possibility of selling of hot air where the actions never actually took place, but they're actually counted as having taken place. So we need very robust accounting procedures, very robust monitoring and verification processes, very robust transparency. Basically, we call it the transparency mechanism. And then we also need to ensure that even as we transition, that we don't perpetuate imbalances that were existed. Africa was a very low uptake of CDM, and we hope that this does not happen at the new markets. And what are the challenges? Of course, climate finance, building the skill sets. The collapse of the market affected transition and market confidence. And even as we delay, because we lost a year or so to COVID, and also the uncertainty before, because the Paris rule book came about in 2016, but it was minus the rules for Article 6. Finally, we got them in Glasgow, but we still need to make modalities and procedures. So that delay affects the positive signal. And so in conclusion, those are some of the pictures. You can imagine the benefit it's brought. Those who schooled in boarding school like me, firewood trucks would come in on a weekly basis, but with improved cook stoves for institutions, I'm sure that is probably monthly. There are savings in money, savings in indoor health, savings to the economy individually and globally, and most importantly, addressing the climate actions. Thank you very much.
Thank you so much, Daktari, for that very, very elaborate picture of, Kenya, the state of carbon markets in Kenya. And now to proceed to our next speaker, who is Ms. Bianca Gishangi. Bianca is a climate change and climate finance expert, and she's a coordinator at the East Africa Alliance on Carbon Markets and Climate Finance. Bianca, are you ready to proceed?
Yes, I'm ready. Can you see the screen?
Yes.
Great. Thank you very much for inviting me today to the Climate Lawyers Cafe and to LSK Nairobi. And thank you to the previous speakers for providing a lot of insight. So if there's anything that has already been talked on, I won't touch on it again. And today I'm speaking on carbon markets in the context of Article 6 of the Paris Agreement and the implications for countries. So as mentioned, I'm the coordinator for the Eastern Africa Alliance. And so I have to give a bit of context as to what the alliance is, so you can understand the context of the countries I'm talking about. So the Eastern Africa Alliance was launched in 2019, June of 2019, and membership comprises of Burundi, Ethiopia, Kenya, Rwanda, Tanzania, Uganda, and Sudan. And what the alliance does is it promotes long-term participation of Eastern Africa countries in carbon market activities. It's very country-driven, and the activities are based on what comes in from the members. So each of the member countries put forward a focal point, which is from the respective ministry or environmental management authority that is in charge of carbon market activities. So the focal point for Kenya is Dr. Arno Mwambia from NEMA. And each of the other countries also send forward a representative. So just very briefly, the objectives really is to enhance Article 6 implementation in the region through supporting new cooperative approaches that are coming up under Article 6.2, and also the transition from the Clean Development Mechanism that Dr. Mwambia has really gone into details about into Article 6.4. So over the past 2 years, because we didn't have a decision, it was more about Article 6 readiness, so getting everyone aware of what this will entail. But now that we actually have a decision, it's really about going into implementation mode. We also support active and well-coordinated participation of the delegates at the UNFCCC negotiations. So this is at the COP, and from next year, we'll also be supporting for the SBs. So Dr. Mwambia mentioned that there's a Substan SBI, and we normally have those sessions in the middle of the year. And then we have the COP negotiations, which are normally at the end of the year. And what we do is we make sure that the negotiators have all the up-to-date information on critical issues relating to Article 6 and can help them now contribute to their own country positions, but also to contribute to the AGN, the Africa Group of Negotiators strategy as well. So, and then also because we're a regional platform, we do promote a lot of exchanging of experiences and sharing of lessons. So this is a list of our activities. Because of time, I won't go into all of them, but I do urge you to please look into it. There's a lot on trainings we do for Article 6 with different stakeholders, private sector, government. We've done a lot of studies. We've done carbon market profiles on each of the member countries. So if you'd like to see more statistics, you can have a look at our website. And we've also compiled it into a regional approach. And we also have a few courses. We've done some on carbon taxation, and we also collaborate a lot with the West African Alliance, which is similar to ours, a bit older. And we also get a lot of support from the regional collaboration centers. The one serving this region would be the RCC Kampala, where the alliance is actually based. But I'll go straight into Article 6. That was just to give you some background and some context so that you may understand. I'll be referring to the countries in the Eastern Africa region. So Article 6 of the Paris Agreement provides for, just give me a second, yeah. It enables parties to voluntarily cooperate on implementing their national determined contributions, and using Article 6 can allow for high ambition in their mitigation and adaptation actions. So adaptation is important because, as Dr. Mwambia has mentioned, adaptation is a very top priority issue for African countries. So we are looking at Article 6 being able to contribute to both mitigation and adaptation. So when you go into the details of Article 6, you'll find that majority of what we talk about falls under 3 different sections, which is usually around Article 6.2. This is around cooperative approaches, Article 6.4 and Article 6.8. So under Article 6.2, and this is basically when you go to the Paris Agreement document itself. So when you read Article 6, this is what it comprises. So in 6.2, countries or parties can engage in cooperative approaches that use internationally transferred mitigation outcomes, known as ITMOs, towards the NDC contributions. So in the past few presentations, you've heard about the CERs that were being mentioned by Lydia and by Dr. Mwambia, which were products of CDM, and VERs, which are products from the voluntary carbon market. Those were the units under the Kyoto Protocol, but now under Article 6, they're going to be called ITMOs. they are real, they are verifiable, and they're additional. So and this is basically bilateral between countries. So, and it's not developed or developing, it's pretty much any country that wishes to cooperate with another. So there's no restriction now on whether you're a developed or developing country, because in the CDM, it was very strict that it was a developing country selling to a developed country. Now with the Paris Agreement, it's not, there's no bias in terms of who you can cooperate with. And there's been a lot of piloting. Some of the activities under this, we have the World Bank Standardized Crediting Framework, the Joint Crediting Mechanism from Japan, NEFCO have an initiative known as NICA, and the CLIC Foundation has a mandate actually from the Swiss government to buy ITMOs from different countries, to which they use towards their transport targets, as well as the Swedish Energy Agency. So there has been a lot of piloting before Article 6 was decided on, and now that there has been a decision, you're looking at now projects actually coming up under these cooperative approaches. Then we have Article 6.4, which now establishes a UNFCCC centralized mechanism under the authority of the CMA. The CMA is the Conference of Parties serving the meeting of parties to the Paris Agreement. Basically, when you have the COP, which is what Dr. Mambia mentioned, that each of the countries who are members of the UNFCCC, they go to the COP, but the CMA is what now guides the Paris Agreement, whereas the CMP used to guide the Kyoto Protocol. So now we have a new mechanism under Article 6.4, and it's going to have a supervisory body, which is also under the CMA and the UNFCCC. Now, the difference, of course, between 6.2 cooperative approaches and 6.4 is that 6.4 is the governance comes from the UNFCCC, whereas in 6.2, it's between two countries. So there's no oversight from the UNFCCC in terms of governance, but what they do is provide guidance, and I'll go into that. And then Article 6.8 also recognizes the importance of non-market approaches in international cooperation. However, for purposes of this presentation, we'll be focusing on the markets sections, which is 6.2 and 6.4. So after 6 years of negotiations, so that's from 2015, parties finally decided on a guidance for cooperative approaches, rules, modalities, and procedures for the mechanism, and a work program for 6.8 non-market approaches. As I mentioned before, 6.2 has a guidance because it's technically not governed by the UNFCCC. It's pretty much how countries can bilaterally agree on how to do this cooperation. Whereas the 6.4 mechanism technically replaces the CDM. So it does have a supervisory body, and it has stricter rules and modalities of procedures as compared to the guidance. But the guidance is still important because countries have an obligation under the Paris Agreement to report, and Article 6 is a part of the NDC. So you definitely have to report on Article 6 as well. So there needs to be there's a very strong emphasis on transparency for Article 6, and the guidance is very clear on that. So even if countries decide to cooperate amongst each other, they have to be very transparent and to make sure they're not compromising on environmental integrity and they're not double counting. So now with the decision, which was decided at COP26 last year in Glasgow, the parties can authorize ITMOs for use towards NDCs and to other international mitigation purposes. So I think you may have heard Dr. Mambia mentioning CORSIA. So that is the offsetting system for the aviation industry. And that's a very separate system from the UNFCCC, but it does allow units coming from the UNFCCC to be used in that offsetting scheme. So under the UNFCCC, you have to be transparent if your units are going to go to CORSIA. And for other purposes, would now be associated with, say, the voluntary carbon market activities, examples of which Lydia had mentioned, the gold standard, VCS, which is now known as Vera, and all these other standards, Plan Vivo, there are quite a few. So that's now what other purposes is usually interpreted as. So when you combine CORSIA and the other activities, they're known as other international mitigation purposes. So once countries authorize the ITMOs for transfer, they shall apply corresponding adjustments. So that is something that has been decided on. Corresponding adjustments is something that parties actually decided on even before the guidance was agreed on. It was something that they agreed they would use to avoid double counting. This is what all countries agreed on. And it's basically, it's based on the system of the principle of double entry, whereby if you have ITMOs and say Kenya has ITMOs and you transfer it to another country that uses it towards their NDC, Kenya cannot use those ITMOs to the NDC. So you have to clearly show that they've gone to another country and that you haven't used it for your NDC to show that there's definitely no double counting. So since that's the background on Article 6, and now your country has said, okay, we'd like to take part in Article 6, what's the implication of that? What does it actually mean to be involved in, taking part in Article 6, especially for developing countries such as Kenya and those in the region, the Alliance member countries? And basically, it just means that for you to actually benefit from these carbon mechanisms, you have to have the capacity to do so. And I'll go into detail into how this capacity is needed in various aspects. And of course, you'll be able to see where the lawyers fit in. And one of the things that the Alliance did actually before the decision came in was to do assessments of all the countries on their institutional, legal, and infrastructure setups, just to understand what was already existing, but to also see if there were gaps or to provide recommendations so that they could effectively engage in Article 6 once it was decided on. So each of the countries received an assessment, which they can use for their own internal purposes, but there's a regional synthesis report that is available on our website, and it's partly what we use for enhancing on what the capacity building required is. And there's a lot to be done, but I will just narrow it down for the purposes of this presentation to where the institutional regulatory developments and infrastructure are really required. And the first one is on authorization of transfers of ITMOs, the application of corresponding adjustments to avoid double counting, reporting and tracking requirements for the transfer of these ITMOs, sustainable development with regard to your national priorities, your strategies, your regulations. Decisions on benefits sharing is definitely required, just as Lydia had mentioned before. It's very important to see where the end benefit is going and in ensuring there's environmental integrity. So in terms of authorization and application of corresponding adjustments, there needs to be a national decision, first of all, institutionally, on which institution is going to take up these responsibilities of Article 6 and the responsibilities of providing the authorization. And it's been agreed by the countries in the region that they definitely need authorization procedures. So before you had that there's a letter of approval that you'd get in CDM, and now people are talking about letters of authorization, but it's actually going to be a lot more than that. There's going to be a process for you to actually get that authorization, and you need to decide on the elements as a country what the criteria would be, and countries would have, and parties, the private sector developers have to meet certain requirements. So even this letter of authorization, there's a lot of debate as to how basic it will be or how detailed it will be, depending on the different countries. And a lot of countries are indicating that they will have a lot of elements to show that you have actually met certain criteria. So we do recommend having similar procedures in the region for this, so that you can use it for different types of cooperative approaches you have with the different countries. So having the same procedure for all types of cooperative approaches is more efficient. And then the thing is also that these procedures have to make sure that you link it to the reporting and NDC accounting. As I said before, Article 6 does not operate in a silo. It is part of the Paris Agreement. It is part of your NDC. So you have to show how it's contributing to the NDC, and there's a lot of reporting. Now, when it comes to corresponding adjustments, this can be calculated, and you can do this using different tools to perform the corresponding adjustments. And then you can use that to now report when you're doing your biannual transparency report, which is now the NDC reporting that happens every 2 years. So you definitely need procedures and tools for that. And you need the capacity within the relevant ministry, basically people who understand what's happening, just so that you make sure that you're inputting the right formulas or you're doing the calculations properly. The good thing is you can automate a lot of this, but you still need human capacity to understand what's going on and to make sure that the reporting is done properly. So the other good thing is that there's a lot of CDM experience and institutional structures, which the DNA, which is NEMA, expounded on. So the good thing is you can build on such existing structures, but you also have to link with the institution that is responsible for NDC reporting. So in terms of reporting, I think I just mentioned you need to have reporting templates. So the guidance on cooperative approaches is quite clear on this, but you can also tailor it to national and institutional setups. Parties for Article 6 will need to give an initial report. You'll need to give annual information that goes to the Article 6 database, and you'll need to give regular information, which is now where you report on the progress of your cooperative approaches, on the corresponding adjustments. So this now brings us to infrastructure, which is often looked at as registries. And this has to link, as I said before, to the NDC MRV system. So there are different registries that are available. Kenya is looking to have a national registry, and different countries are looking to have their own registries as well. But the UNFCCC will also provide an international registry for the countries that don't have the resources to do this, because they cost money. The World Bank has also been developing infrastructure through blockchain. So there's very many different types of systems out there. The thing is though, sometimes it takes some time, it takes a while to build a fully fledged registry, but we do recommend interim solutions. So there's nothing stopping Kenya from at least tracking what's going on using very simple systems, example like Excel-based or which other simple systems are out there, in order to just know what's happening with the different activities out there. So, and then you can obviously do a cost benefit analysis to see if you want a really fully fledged one like the ones the EU use, or you want something that's a bit simpler or that can link to the other countries when you're doing your transfers. So you have to understand that this needs staffing and resource requirements to operate the registry and the interface for this. So basically, So that now brings us to Article 6.4 and the CDM transition, because as you heard before, Kenya has a lot of CDM projects, and the question now is, since the Paris Agreement is now operational and Article 6 is operational, there's a whole transition that's going to happen. And one of the key things that needs to be ensured is environmental integrity. So this is making sure that you have things like conservative baselines, that you ensure additionality. Standardized baselines have been quite useful for the region. So that has really helped in providing values that can be used across different countries in an efficient manner. And basically, so one thing we can say is that, as Dr. Mamba said, you don't want hot air, you don't want fake units. So you need to make sure your baselines are conservative and that you're not overestimating emission reductions. Then when it comes to sustainable development, countries need to develop the criteria to evaluate these projects, their NDCs, and contribute to and show how they're contributing to sustainable development. So I think Kenya had a procedure for this already under the CDM, and maybe they can improve on that or use the same thing, but some countries don't have that at all. So it's up to the countries to do that. You can definitely improve it by now incorporating this issue of benefits sharing. So there needs to be discussion and debate around that to see how it contributes. And then also there's a lot of other reporting that happens, like with SDGs and other institutions, government institutions. So find a way of coordinating with them so that, that everyone is up to date on everything. So, of course, now for lawyers, what does all this mean? And I think you're very key in the aspect of policy and procedure development. Now, when we're doing this study, none of the countries had a policy specific to Article 6. Kenya and Uganda have climate change acts, so that's a good stepping stone or a first step. But really, there needs to be a policy to which these procedures for authorization and corresponding adjustment, that they can all be anchored to. So you can do this hand in hand. You can work on the policy, deciding what carbon rights. So the issue with carbon rights is that's a very national debate that needs to happen. because the guidance just gives guidance on ITMO transfers, doesn't tell countries what to decide on that. So Kenyans have to like come up with their own standards on what it means, on what carbon assets mean, on what carbon rights means, and how all this links into each other. So of course, even while you're doing the procedures for Article 6, this can be linked to the policy that's happening on a larger scale, and make sure that there's a lot of stakeholder consultation, have deadlines, and then there needs to be, and then once you do this, you can, to help you do this, you can establish very dedicated Article 6 teams and working groups. So a good example of this is, so this week, actually, Ghana were giving the experience on how they're doing with Article 6. They've already drafted their Article 6 policy, and they're actually receiving comments from stakeholders at the moment. But the thing is, Ghana started their processes even before the decision started, and they have a dedicated interministerial committee that works with all the coordinating ministries, coordinate with all the other ministries to make sure they're up to date. And they have a dedicated Article 6 office, and they have an Article 6 board. So basically they are dedicating resources to take Article 6 very seriously, and it's definitely quickening the process. Brazil have the same thing. They have a very detailed interministerial working group, and even that working group has further technical groups that now goes into the very nitty-gritties of what's needed to come up with these policies. Japan have already come up with their policy. I think they've done their stakeholder consultation. They're actually looking to translate it so that other people can look into it. So basically there's a lot of momentum in other countries. And when you look at Eastern Africa, I'd say that Rwanda also has already tendered out to develop these policies. So they're already in the process of trying to work on that. Uganda has done a lot of stakeholder mapping in the sense that they have put down all their needs, and they're working with development partners to try and link up to see what each of them can contribute towards. So of course, as lawyers, you are very integral to this particular process. And I think I'll just reiterate by saying that you really have to align the MRV for Article 6 with NDC accounting and reporting. There are opportunities for digitization there. There's a lot of stakeholder capacity building that needs to happen beyond the ministries. So like now what we're doing with the lawyers, what you're doing with private sector and financial institutions. What I mean is proper immense awareness and technical trainings, not just a one-off webinar. Like you need a program to really go into all these details, because you can discuss all of this actually in a lot of sessions. So just to make sure that there's a deep and thorough understanding, and that even as lawyers, if you're contributing, say, to the country position or to policy, you have good knowledge and background on this. Then of course, with CDM transition, there's going to be a lot of help from the UNFCCC because that's a centralized mechanism. So they will help a lot with expounding on baseline approaches and reviewing of methodologies. We will need to scale up activities for this to also have an impact. And lastly, there will be a need for local and regional verifying institutions and auditors. So I will stop there because I have said a lot. And, I know we've already gone way past time. And I just want to leave everyone with the resource for the UNFCCC. If you click on this link, it has all the decisions related to Article 6. So like what was decided on at Glasgow and what the requirements are for parties, the reporting guidelines, everything. So I just think it's a good resource to have. Go to our website as well. There's a lot of resources there. And yeah, we're always happy to help, even though we're on a regional basis. Yeah, thank you.
Thank you so much, Bianca, for that very elaborate discussion into what now Article 6 means for countries. And I think we can all see there's so much work to be done. And with that comes a lot of opportunity for lawyers to get involved. I know, Bianca, you have to rush. So if anyone has questions for Bianca and maybe she's not able to answer them at this point, we'll make a point of responding to those questions on email, because I believe we have your information now. Circling back to Lydia's Lydia's presentation, I have a concern, maybe one question. I'd like to know whether you've come across any projects, transactions, which actually do have a benefit sharing mechanism in place, and how does this look like? That is benefit sharing mechanisms between project developers, consumers, and maybe the community. Examples, maybe in the clean cooking stocks, in the forestry sectors. You come across any benefit sharing mechanism under carbon markets? How does that look like? Lydia?
Thanks, Immaculate. Usually, the standards, the carbon market standards usually require project developers in what we call the PDD, the project development document, the project design document, sorry, to show how, to show some kind of benefit sharing mechanisms that they have in place. And you'll find that most of the time they indicate how, especially especially forestry projects, there's a REDD+ project which has safeguards and has quite elaborate descriptions on benefit sharing and protection of indigenous peoples and local communities. So this is usually required by the different standards. But then in addition to that, I think all standards, the standards have how you can describe sustainable development benefits, and then you get an additional certification that, for instance, in Verra it's called SD Vista. So this makes your carbon credits even more valuable and has quality. And for this, you usually describe how your project is contributing to the sustainable development goals, how it's reducing poverty. For instance, you can describe how this is providing employment to, it could be specific, like it's providing employment to women, or how this is increasing employment to the community. And some of these projects also have, in addition, they have like what I'd call community projects, like they train women on certain type of forestry, or on certain types of agriculture, then they provide seedlings to these women. And then so they have different kind of benefit sharing schemes that they usually have in place. And they also have this SDG. And once you have this extra certification that is called, for instance, SD Vista, or there's one called CCB. I don't remember the full name right now. Once you have this, it makes your carbon credits more valuable. So that means it's more expensive. So you're able to sell it at a higher rate. So that is what is happening in terms of benefit sharing at the standards level. But then also some countries have already put in place benefit sharing mechanism. In Kenya, there's none specifically for carbon markets. And I think, yeah, there's none specifically for carbon markets. But I saw, for instance, in the Community Land Act, there's actually a description of how, if you are developing any project in community land, then there's prescription on a benefit sharing, on how you need to make sure that this agreement, how it's agreed on with the community, what percentage needs to be left with the community. So the Community Land Act also has this prescription. And you could actually apply this to carbon projects, as much as it's a general benefit sharing of any investment in community land. You can apply it to carbon projects. But other than that, a lot of countries, and I know Kenya is also discussing it, have also their own benefit sharing mechanism that say, if you develop a project, then a certain percentage need to go to the community. It could be in terms of direct payment, but it would also be in terms of indirect payments. Yeah.
Chair, if I could add with regards to that, I'll just give an example of one of the KenGen projects in the Olkaria. I don't know whether you can hear me. This is Omambia.
Yes, please proceed.
I don't know whether Bianca's dropped off. Bianca worked for KenGen before she left to be our coordinator, and she may be aware of this, that One of the community benefits sharing mechanism is one, at the inception of the project, community liaison committees are established, where KenGen has liaison committees which identify, prioritize, and select community priorities which they request to be assisted through the project. So one of them, like I know in the Lucaria zone, is provision of watering points for the pastoralist, largely Maasai community, which is there, rehabilitation of schools, building of extra classrooms, provision of water point services. And these are requirements within the CDM sustainable development criteria for the country. So when a CDM project is, I never dwelt on the slide on our criteria, but one of the criteria of sustainable development criteria is ensuring that there are benefits to socioeconomic and otherwise community benefits to the community. So that will include job creation, where as much as possible, the job should be provided to the community, and this will be varied because some projects which are very highly skilled, like say installation of geothermal, which you may not get immediate labor there, and as much as possible avoid to bring expatriates to do jobs which can be done internally. So that is one of them. And then we have the one for cook stoves. Companies used different approaches for benefit sharing. One was because you may not be able to get each and every person who bought a cook stove to give them back their money. They instead sold the cook stoves at a subsidized rate. And therefore you could be able to buy the cook stove instead of the original price of say 5,000, you can now get it in the supermarket at 3,500, but the value is much higher. And then they established through microfinance an ability for you to be able to purchase, you get the cook stove in advance and you pay 20 bob over time. And then of course the provision of seedlings and allowing you, for example, if you have established trees under the forestry project, that you can reap the benefits of the tree, which are multifaceted without necessarily cutting the tree. Thank you.
Thank you so much, Daktari. We have a question from Mr. Tokua, and he's asking, what is the state of local ownership of carbon trading projects in the forestry section, especially on public and community land? What is the state of local ownership of carbon trading projects in forestry, especially on public and community land?
Forestry activities, this is Omambi again, I guess I'm supposed to respond to that. Forestry activities that have taken place are in two types. Those which have taken place within farmer communities are small scale afforestation and reforestation projects. Those were largely done. The first one that was first registered under voluntary carbon market was TIST, Tree International Sustainable Something. The acronym is TIST. It's in Greater Mount Kenya, Meru area. Then we have Greenbelt projects, also afforestation, reforestation in community, in individual lands where the nature of tenure is private land ownership. So for example, I have a farm and I dedicate a portion of it, let's say a minimum of 10% to afforestation, reforestation. So the ownership therefore of the trees is mine, but I sign an agreement that I will not cut the trees for a duration that they are under the carbon project, for the tree to be able to sequester the carbon. But the benefits that come to my land in terms of nutrient enrichment, firewood or fruits, if there were any, then and other, you could do the trimming of the trees, those or beekeeping on the trees, those are yours. At the end of the contract, when the trees are no longer within the CDM carbon trading, then the trees are on your land, they are yours. You can choose to fell them, or you can choose to keep them for other purposes for sustainable land management. For those, there are other second part of afforestation projects, those that are taking place in community lands. That is, the nature of land ownership is community trust land, or taking place in gazetted Kenyan forests. So for example, afforestation, reforestation, Aberdare and the Mau, those are government land, therefore it is state property. And of course, the KenGen, though it's a private company, it's also a government, it has a government share, and therefore there is clear contractual mechanisms of power purchase agreements, and also the carbon offsets, how they share the benefits to the shareholders who are Kenyan shareholders when they earn the CER. So that is when their emissions reductions are being traded and the money has trickled to Kenyan.
And just to add on what Dr. Mambia had said, one example of projects that has been developed in a private-public partnership method is the Chulu project, where part of it, I think, is on a national park. So what they have done is they have developed a board, and then part of this board is made up of KWS, KFS, and then since part of the project is also happening on community land, they have these communities are sitting on the board. And and then the project developer, so they have this board that has this membership. And what happens is that when carbon credits are sold, whatever revenues that are coming from carbon credits are then distributed based on a percentage that they agreed on. So part of it will go to the communities, and then part of it will go to KWS, KFS, and then part of it will go to the project developer. So this is one kind of project which has been developed on public land as well as community land. And this is the kind of partnership they've entered into.
I think that also relates to the Red Plus Kasigao project, which is both on community and private land. If you know, the Greater Kasigao is in Taita Taveta, Voi area, Voi Kasigao area. There's a bit touching on the national park, there's a bit on the rangelands, and a majority on community lands. And they also have an agreement, which is also on the voluntary carbon market. And the project proponent is Wildlife Direct. If you do a quick Google, just type Kasigao Red Plus project, will come up. Another one is the Mikoko Pamoja project of mangrove restoration. And the mangroves are on the shores, which is, of course, government, or the open, but the benefits are accruing to the communities in a very varied manner. It's one of the success projects under Plan Vivo, and there are quite a number of buyers. It got an award globally, I think 2 awards now. Please just Google Mikoko Pamoja, Mikoko for mangroves, MIKOKO. It will pop up. Thanks.
Thank you, Daktari, and thank you, Lydia, for those interventions. I think this represents sort of a very good example on how benefit sharing, especially on projects in community land, should happen. I know in Kenya, we currently have a bill, a benefit sharing bill. I believe initial comments were taken to the Senate, and I believe when it comes to the National Assembly, they will be needing comments. So at this point, it's really looking at carbon assets as any other plant-based asset, or as any other, as looking at it as minerals, oil and gas, certain projects. So that it's something that can eventually trickle down to benefit communities who are
Lydia,
also...
can I add something? Sorry, Immaculate, can I add something?
Yes,
I
please.
mentioned that Kenya participates in the joint Japan credit mechanism. And that mechanism, for the offsets that have been done, the agreement we have between Kenya and Japan is that 50% of the carbon emissions reductions and the money earned goes to Japan and 50% to Kenya. Kenya, the government. I don't know whether you consider Kenya as part of the community, but yes, that's it.
Thank you so much for that intervention. A follow-up question was in reference to the Community Land Act. Since this has been passed sometime in 2016, would then these mechanisms be applying retrospectively? And I guess just in part to address that, it's also to refer to Article 69 of the Constitution. Be it, or rather, as much as we may not have a very, very specific framework on carbon share, on benefit sharing in carbon markets for Kenya, we can always refer back to Article 69 of the Constitution, which essentially speaks about benefit sharing on resources and also to promote sustainable development. I see we are a bit out of time. This directed to Dr. Omambia, what kind of support, what kind of intervention do you see that the government will need from the legal profession, just as we part?
Thank you very much. The government needs a lot of legal support in all these decisions. I think Bianca was able to elaborate them, and also Lydia. One, we need a specific Article 6 policy. Currently, as a country, we have a climate finance and carbon trading policy, which was formulated by the National Treasury, obviously, because climate finance is a finance obligation for the Treasury. It came into place in 2017. It is going to undergo review. We are also setting, the National Treasury is also mandated to have a climate change fund under the Climate Change Act. And that fund has already been established. And there's an entire climate change directorate within the National Treasury. And that, of course, will require a lot of legal support in terms of all the contracts that we have to enter for climate finance. And by when I mean climate finance, that does not only relate to carbon trading, but climate finance that comes into the government to support all climate actions, adaptation, mitigation, capacity building, technology transfer, and otherwise. As I think we are aware, as an obligation, ministries, department, agencies, and counties have been mandated to have climate change sections by the Climate Change Act. And NEMA currently, fortunately today I was given an additional officer. It's an exciting afternoon for me. We are now three full-time and several part-time climate change persons. We rely heavily on our legal department when we do international and regional negotiations. Also internally, we are making regulations to implement the Climate Change Act. I can see one of our lawyers is here, Cynthia Sakami. They are an important part. Actually, they are normally the first priority when traveling for negotiations, because they can understand the shall and may, because in negotiations, diplomatic language is very tricky. You need a lawyer to nudge you and tell you, no, that is going to be binding. And we go with our lawyers, and we have been fortunate that the lawyers that have served the Climate Change Act so far, two of them are now judges. That is Edward Wabuoto, the judge, and Christine Nontatua, who is also a judge in the labor court. So I hope Sakami is next, and all of you who are joining here and trying to join us. Secondly, we also need the lawyers to guide us in not only unpacking the decisions, because the UNFCCC, the regulated market, is purely a legal obligation. What we do in terms of the letters of approval are a commitment of the country that I have approved this project taking place in position X, and is going to do all that pertains to the Paris Agreement's cooperative approaches. And that is a letter which either party can default. We have the powers to withdraw the letters, and those powers only come through lawyers. And contractual agreements that may come in between the projects, and also those that relate to benefit sharing and all that. So lawyers play a very important role. Actually, the Article 6, when you attend the international negotiations for Article 6, everybody who is negotiating on it, speaking on behalf of a country, that is, are mostly lawyers, and few technical officers will be there to speak what we have learned over time. So it's purely because the conventions, they are global treaties, therefore they are legal instruments. It is the bedrock of lawyers, and you have a lot. You can actually create a new portfolio for yourself as you unpack the Paris Agreement and the other instruments taking place in the climate change space, in the environment space. Globally, we have over 4,000 multilateral environmental agreements. Kenya is party to quite a number of those, and they all require unpacking and guidance and a balancing act, not to sell the sovereignty of the people at the table of solving the climate action. Thanks.
Thank you so much, Anne. I have been taking notes. I certainly, everyone else has been taking notes. So now we're coming to an end of today's webinar. I understand there's so much that still needs to be discussed, especially in this field. kindly just send in your questions if you have any questions regarding today's webinar. I'm just typing our email address in the chat section. Yes, there you go. So if you have any questions regarding this webinar, regarding the work we do, feel free to reach out to us and we'll do our very best to answer your concerns. So once again, thank you very much. I appreciate the time you've taken to join us in this discussion today, and I hope it's been very, very beneficial. And then so enjoy the rest of your afternoon, enjoy the weekend, and see you very soon. Thank you so much.
Thank you for inviting us.